Hi, I'm Jeri Towler, and welcome to CASA board trainings. There'll be several different trainings, and the one we're going to talk about today is legal responsibilities of board members. We're going to start with legal responsibilities of board members, and specifically the IRS's recent interest in tax-exempt organizations. You may see them called EOs, which stands for exempt organizations. There are more than 1.5 million public charities in the United States. Now, those charities do not have to pay taxes on their income, and not only that, but individuals who give money specifically to 501c3s get a tax-deductible donation. This leads to a loss of revenue to our U.S. government, which exceeds $50 billion. If we add the churches into this number, it increases by about another $80 billion. So all of a sudden, the IRS is getting more and more interested in tax-exempt organizations. This really began with Sarbanes-Oxley in 2002, and there are portions of Sarbanes-Oxley that actually apply to not-for-profits. The accounting practices do not, so we don't have to worry about that. It doesn't mean we shouldn't be utilizing those accounting practices, but what does apply is a Whistleblower Protection Act, a document destruction, and retention. Those are the biggest points of Sarbanes-Oxley that we need to consider. Of course, we know that we already need to have a conflict of interest policy. Then in 2005, the IRS actually went to Congress and said, we need funds to monitor tax-exempt organizations. And Congress gave them that money. And then by 2006, we saw a change in the Pension Protection Act. And in 2007, all tax-exempt organizations are required to file a tax return. That's where a lot of organizations began losing their tax-exempt status in 2010, was because they had not filed tax returns for 2007, 8, or 9. So now you have to make sure that every organization that you're with, that you sit on a board, is filing a tax return. Then in 2008, the IRS actually started putting out white papers on their role in the governance of exempt organizations. This was really new. And by 2000, well, also in 2008, we saw that the reformation of the 990 tax return. Now, it was interesting in how they did that, because they actually went to donors and said, we want to know, Mr. or Mrs. Donor, what you want to know about tax-exempt organizations before you give them any money. And that's why at the very top, you literally have the name of your organization, your tax-exempt status, your mission, and the next question is, how many people on your board are interested parties? That means they want to know, the donors want to know if you're doing business with your board members, because most donors do not want to give dollars to organizations that are doing business with their board members. So that's just something to keep in mind, and we'll talk about that a little bit later. By 2009, the IRS put out a governance check sheet, an audit checklist for exempt organization agents, because they had just hired around 6,000 new additional agents just for the tax-exempt organizations. And this checklist doesn't deal with money at all. It deals with governance practices. So all of a sudden, if we are audited, our governance practices are also audited. So this is a huge change from what we had seen in the past. There's also a Schedule A that some changes were made to the public charity status and the requirements of meeting that public support test, and that new schedule came out in 2010. And your CPA will be the one that will be able to individually answer questions for you on Schedule A. Now, the good news is that we have state statutes that protect board members. And we actually have these legislative findings that say we're not going to hold board members liable because if we do, then no one's ever going to serve on a board. And there is also a federal Volunteer Protection Act. So as we get into all these issues, I want to make sure that you know, as long as you're acting in good faith, that you're going to be just fine. So we find these statutes at Title 18, beginning at Section 866. And it says that as a board member, you are not going to be held liable for the negligent act or omission of an employee or for another director. And you're not going to be personally liable for damages of breach of fiduciary duty as a director, unless you fall under one of these exceptions. And here's the exceptions. This is how you can get into trouble, is that you breach your duty of loyalty to the organization. And that means you're not acting in the best interest of the organization. You're acting in your best interest. And this is a difficult thing for a lot of people to understand. I deal with it all the time. When you step into that boardroom to make decisions, your personal preferences really should become irrelevant. You need to look at what is in the best interest of the organization and make decisions based on what is on the best interest of that organization. Sometimes what we need to do, we need to say, okay, let's make the assumption that everyone sitting at this table right now is no longer here. And how do we want this organization to look in 20 years? So if we're making decisions that are going to guidance that we're going to provide for those board members 20 years from now, what do we want that to look like? And sometimes that helps, because that is a difficult process to walk through. And then any acts or omissions, that means you act or you just choose not to act, that are not in good faith, which involve intentional misconduct or a knowing violation of the law. You just can't know that a law is being violated and choose to do nothing when you sit on the board. And then, of course, if you receive any type of improper personal benefit. Now, this is a big issue, and we're going to teach a whole section on this because this is where we can get in trouble. There are substantial penalties that deal with improper personal benefits. The person receiving the benefit may have to pay that money back, and if they don't, the IRS can actually penalize them up to 200% of the benefit that they received. That penalty is paid directly to the IRS. Board members can also be sanctioned for approving a personal benefit to another director. So we want to make sure we're very cautious if we're doing business with our board members, because sometimes our board members think they're doing us a great favor and they're being very kind, but if we're doing business with them, we have to make sure that we're protecting them. And then there's also intentional torts or grossly negligent acts or omissions to any director. Now, an example of a grossly negligent act would be, this was probably 12 years ago, I had a national group call me and say we were at a conference and our treasurer announced during our board meeting that we were not following our financial policies and procedures. It was at a conference, we had a lot going on, and we chose to table that we didn't have time to deal with that right now at the meeting. The next conference rolls around. They only have one annual meeting. They had a board member from each of the 50 states. That was the only time they got together. Next year, the following year, at the conference, the new treasurer, the old treasurer resigned when they chose not to do anything. The new treasurer said there is $250,000 missing. When they chose not to act at that meeting, that was a grossly negligent act. The treasurer put them on notice that they had a problem, and they chose not to do anything. So when you're in that situation, you need to do one of two things. You need to address it immediately, or you need to table it and make sure that you have a meeting immediately to discuss those issues, or you can assign it to a committee to make sure then that committee is going to investigate immediately. You do not get to put those things off. Another area that can get us in trouble in grossly negligent acts, or if we would have an employee show up and say, I am being sexually harassed, or I have this issue going on, I'm being discriminated against, and we choose to table that, and 6 months later we have a larger problem, and there's a lawsuit, then they can come back and say it was reported and you chose to do nothing. So those are the types of issues that we do not hesitate. We make sure we assign it to an HR committee, a finance committee, an executive committee, or the board gets back together as a whole and we deal with the issue immediately. Now, we do have Title 10, Section 11 of the Oklahoma Constitution that says anyone receiving any type of interest, profit, and that's a perk, even a perk, that it can be considered a felony. So we need to make sure that we're very cautious on giving our board members any type of benefit. Now, this is when state funds are involved. Of course, your money is running through the Oklahoma CASA Association, but I want to make sure you're very aware of this because you do receive state funds. And so we have to make sure that we're not giving our board members a lot of benefit. Now, of course, these can't, little thank you things and lunches and things like that we're going to be fine with if they're showing up at those meetings. But please also keep the Oklahoma Constitution in mind. So in a nutshell, here's your legal responsibilities. On a national level, if you do research on this, which I hope you do, I hope you read on this and find this absolutely fascinating like I do, you have 3 primary responsibilities. Those are the duty of care, the duty of obedience, and the duty of loyalty. Now on your PowerPoint, you'll see under duty of care, make good faith decisions. That is our state statutes. And our state statutes also talk about being true to the purpose of the organization. That's that duty of obedience. Or acting in the best interest of the organization. That is really that duty of loyalty. And the board members are absolutely the responsible party. So sometimes I've had groups that get a board agreement that says we're the responsibility as the board, and they go, oh, no, cross that off. I don't want to be with the responsible party. If you're sitting on a board, you are the responsible party. And we have to make sure that we know who those responsible individuals are, because sometimes that gets confusing, especially when we're trying to be nice. We may allow our founder to show up at board meetings and vote. We may allow people that have been on our advisory committee that or maybe no longer are actually board members, and we allow them to vote. We create risk for them when we do so. That responsible party, that governing board, is also listed on the 990 tax return. They are also covered under your directors and officers insurance, often called D&O insurance. And I want you to have that. I want every board that I deal with to have directors and officers insurance. What that insurance does is anyone would ever sue your organization, it will step in and cover your defense. Now we have all these fabulous state statutes that protect us, especially when we're acting in good faith. We are going to be protected, but that doesn't mean that we're not going to have to pay for our defense costs unless we have that D&O insurance. Well, that D&O insurance is only going to cover the governing board. So let's make sure we're very clear on who sits on the board, who has a right to vote, so we know who the responsible party is, so we know who is covered by insurance. And this is normally where we're really just trying to be nice to people, that we actually create liability for them. So please go back and make sure that your documents are clear on that. Right, we're going to go into a little bit more of that duty of care. This means that we are not going to pay more than we absolutely have to pay. So I have acquired bids to determine fair market value. If we can do that, that's great. You may not always be able to do that. But an example, when we're also doing business with board members, if we're going to exercise that duty of care, we just need to make sure that we have some idea. Have we looked at rates? Have we looked at what all attorneys charge? Have we looked at what all plumbers charge if we have a facility? Have we looked at different banks and their fees? Have we looked at different printing companies and their fees? So it may not be that we're actually getting bids, but we're doing a little bit of work to make sure that we're paying the right amount. And then I want you asking lots of questions. Sometimes you'll have that person on your board that we kind of consider to be that squeaky wheel that seems to make meetings last longer. Sometimes that person is our saving grace because they're asking all those questions. Make sure that we're asking about conflicts of interest. If we're doing business with a printing company, does one of our board members own a percentage of that company? So really look for those conflicts. Not all conflicts are bad conflicts. It may be a good conflict if we're getting a benefit, if the organization is getting a benefit from having that relationship, but they at least need to be disclosed. And then also, do we really need this project? One issue where boards run into problems all the time is that we as board members are sitting in this boardroom, and when we start talking and brainstorming, that project sounds fabulous. And so we vote that we're going to go after that project. We don't consider if our staff is currently at capacity, if we're going to have to hire 2 more people to manage that project. If we apply for that grant for that project for a $500,000 grant, only to find out that we have to come up with another $250,000 just to make ends meet, and we don't have a path to come up with that other $250,000. So really look at your project and whether it's in the budget and who's going to raise the money. Don't just think your staff is going to go out and raise the money. If you're going to take on a new project, the board needs to figure out who's going to raise the money and how is that going to happen. And then, of course, does that project fit within the purpose of the organization? And I'm going to talk about that in the next slide. But whatever you do, make sure that this is all reflected in the minutes. Those minutes are legal documents. So remember, we talked about those state statutes that you have to act in good faith. Well, the minutes are going to reflect how we acted in good faith. That is our first line of defense if anything ever goes wrong. So make sure you're putting things in minutes. An example of that would be that I was working with a foundation that had a significant amount of money. They did a lot of investments, and I am telling them I want things in the minutes. And I've got a group of highly intelligent businessmen who have been told by every attorney they ever come in contact with, don't ever put anything in the minutes. You can be held liable for those things. In a for-profit world, that is absolutely true. In the not-for-profit world, we have these great state statutes that will protect us if we're acting in good faith. So we can make mistakes. We just have to act in good faith. So an example would be, finally, I went to one of their meetings because the staff said we're not going to get in the middle of this argument anymore. And they were investing in an apartment complex. And so that was my opportunity to say, well, who owns the apartment complex, or whose grandchild is living there that you're going to help? And they said, well, why would you think that, Mike? Why would I not think that? That seems like an unusual investment. And they immediately said, we want to invest in that apartment complex because it outperforms the market by 10%. That's what we need in the minutes. We need who made the motion, who seconded it, the vote. But prior to that, we need the discussion that we want to do this project. We want to make this investment because it outperforms the market by 10%. That's all we need. That then, if they lose all the money and there's a huge problem, we can at least show that they made a good faith decision in making that investment. I don't need 2 pages of discussion. I just need a couple of lines to show how you acted in good faith. And then that duty of obedience. And this is really a big one for CASAs because this question comes up all the time. Well, can we buy Susie a prom dress? Or can we have a toy drive? Or can we pay for, I think another one was karate lessons for one of the children. And if your purpose does not say that you're going to provide services to children, then no, you cannot do that. That is outside of your tax exempt purpose, and it's called mission creep. So go back and look at that purpose. Years ago, whenever you received your tax exempt status, you filed a form 1023 with the IRS. And when approved, that's when you received what we call a determination letter. It's a letter from the IRS that basically says you've received your tax exempt status. So we may have to go all the way back to that form 1023 and those organizing documents to see what you've told the IRS that your tax exempt purpose is. If you've changed that purpose, technically, you are supposed to report it to the IRS. Years ago, we would report it to on a letter with the documents where you had amended your certificate of incorporation and your bylaws to reflect your new purpose, and we would send it in with a letter to the IRS to report the changes. Now we report those changes on Schedule O of the 990 tax return. If you have not done this, then your purpose that's on file with the IRS is the purpose that you have to follow. So, and anything outside of that purpose is considered mission creep, like the prom dress or the karate lessons or the toy drive. If you've taken on a new project where we're starting to spend substantial amounts of money outside of your tax exempt purpose, that is called a diversion of assets. And that is something we certainly want to avoid. And we're actually supposed to report that on the 990 tax return. And believe it or not, we check the same box that you would check if there was embezzlement, because it's any money that's outside of your tax exempt purpose. So let's make sure we go back, look at those originating documents, and find out if that is still your tax exempt purpose or if over the years we've changed it. Now we have two options. We can either go back to that original tax exempt purpose, or we can modify our organizing documents, that certificate of incorporation, which is basically our articles of incorporation, and our bylaws. And then once that's done, then we report that on our next 990 tax return to the IRS. If you want to have the toy drives, if you want to do these other things, look for other 501c3s in your areas that already provide those services, and let's run those programs through those other 501c3s that have those programs already set up in place. We just collaborate with them. And actually that looks great to the community. It looks great to donors when we're actually working with other tax exempt organizations. So instead of trying to come up with this broad mission and try to all of a sudden take on 15 different projects rather than stick with your mission, I would probably encourage you to look at other organizations in your area and see if you cannot collaborate with them. Now here's that duty of loyalty. Now there's going to be an entirely different section where we talk just about the duty of loyalty. But I want you to know that these are all the questions on the 990 tax return that deal with the duty of loyalty. This basically means, are you doing business with your board members? Or are you doing business with your employees? So you have an employee, but they also have a little company over here on the side. And are we doing business with that company over there? The IRS cares greatly about this, and that's where we get into excess benefit transactions, doing business with interested persons, and there's all these huge definitions that have also recently changed. For instance, I used to tell people, an example would be, let's say we're going to build a building. We're doing a capital campaign. We're going to build a building, and so we put an architect on our board to help us through this process. Very smart thing to do. So now we've raised our money, we're getting ready to build our building, or we've raised money to do a renovation, and now we want to hire the architect who sits on our board. I used to tell organizations, just have your architect step off your board. Unfortunately, in 2009, the IRS changed the definition of interested persons to current or former. And former, there's another definition that says that that is 5 years. So if someone is set on your board the previous 5 years of the transaction, prior to the date of the transaction, they are considered an interested person and we could still be doing business with our board members. Now, we report doing business with our board members on Schedule L of the 990 tax return. So I encourage you to get to the end of these sections because this is, or these trainings, because this is an area that we're going to talk more about. It is where we create liability for our board members when we may not think we're doing so. So definitely make sure you watch that section. Now here's some just additional IRS considerations. Of course, we talked about that purpose clause, and that is in our organizing documents and could possibly be on file with the IRS. So let's make sure we go back and look at that. Another area that we need to look at is our dissolution clause. Where does the money go if for some reason we would dissolve? And look at that and let's make sure that is still meeting IRS requirements. The IRS has been tweaking with that dissolution clause a little bit lately, something that I don't like to see, but we want to make sure that it's going to another 501c3. Under no circumstances can the directors ever take funds or assets out of an organization that is dissolving. That is even maybe a computer or a laptop or anything like that. There is we've had this issue, or even when you let someone go, an issue that we need to consider about. When they start carrying stuff out of their office, are those assets of the C3? Or do that piece of artwork or that computer or that desk or whatever actually belong to that employee? So we need to have good asset list. You need to know what your organization owns and what someone else owns. And this really becomes important if for any reason we would ever have to dissolve the organization. The new dissolution clauses coming out from the IRS actually say that if you dissolve, that everything can go to the federal government. That does not have to be in the dissolution clause. And if you come across that dissolution clause, you may want to remove that language and say that it's only going to go to 501c3s in your area with similar purposes to what you do. And if there are none, then it will be distributed by a court of competent jurisdiction in your county. And that way we can make sure the money stays within the county. And this is kind of a laundry list that you're seeing now as far as the conflict of interest policy and dissolution clause. But we do need a conflict of interest policy as well. And that conflict of interest policy, you can actually pull off the IRS's website. It only deals with financial conflicts. So let's say that you're sitting on the board of one organization and you're giving grants to CASA, and you're also sitting on the CASA board. That can be considered a conflict. So you may need to step off that other organization's board and not vote when it comes to giving money to your CASA program where you also sit on that board. So sometimes it's just not a financial interest. And one of the things that you can, when you're thinking about conflicts, think about if this shows up on the front page of the newspaper, how is it going to read in the newspaper? Because sometimes it's not actually a conflict. It may be considered more of an ethical issue, or sometimes it just doesn't look good. So I want you thinking that far down the road versus whether it's just a financial conflict of interest. Then on political activities, you will lose your tax-exempt status if you allow anyone to use your organization to support a political candidate. That is completely forbidden. It is different than lobbying. You can lobby, and lobbying expenditures are reported on Schedule C of the 990 tax return. And you can spend up to 20% of your gross income on lobbying. However, you cannot use a penny of federal or state dollars to lobby. So you have to make sure you track those very well. There is also considered, there is also a 501H election. You fill out Form 5768 for that election, and to make sure you only have to track your expenditures for lobbying. But I want to go back to political candidates for just a moment. If you're having an election in your area, and not just a federal election, but it could be for county commissioner, or it could be for mayor, or it could be at the local level. And someone on your board is a political candidate or certainly wants to support a political candidate. They can do that on their own all day long. But they should not be wearing the CASA t-shirt to go door to campaign. You cannot let them show up at your fundraising events and campaign. So that's what gets us in trouble. Because let's say Joe's on our board and Joe is running for mayor. And then we allow Joe to take the podium at our event and talk about running for mayor. Now all the other candidates that are running for mayor, we have to give them equal time at the podium. So it is best just to completely stay away from anything that involves any type of political candidates. Okay, and then back to lobbying. If you're educating, that's not lobbying. So I want you to call State CASA to talk about that. They have a lobbyist, and allow that to happen through this state level and get your guidance there. A whistleblower policy. That policy is actually part of Sarbanes-Oxley. Remember, we talked about that on the very first slide. That says that you cannot fire someone for letting others know, whether it be the DA, the Attorney General, their boss, other board members, if something wrong is going on. Now, if they're trying to use the whistleblower policy and they're lying, or they're trying to, it's not in good faith, then that's a little bit different. But for the most part, if they say, hey, Joe over here is abusing the organization and they're a staff member, and we turn right around and fire them, they may have an action against our organization under the whistleblower policy. Now, this is a federal law. There is no state whistleblower policy law. This is a federal law. So that kind of ups the ante on us sometimes a little bit too. So make sure that if you're going to fire someone, that it really is for good cause. Even if it's a director where we're not paying them, that doesn't matter. If we're going to remove them because they've reported someone else for improper actions, they can also have an action. So the other part of Sarbanes-Oxley is that document retention and document destruction policy. I have those two together, but they're actually two separate policies. One is we're not going to run in the back room and start shredding documents and erasing emails. That's the retention policy. If there's an action, we have to make sure that those documents are retained in case there's a lawsuit. And then, of course, the document destruction policy is, when did we destroy something? Do we have to keep it permanently? Do we have to keep it 10 years? Do we have to keep it 5 years? And there's actually a list that you can find on the IRS website. When I write this policy, I usually do permanent, 10 years, and 5 years. Because some of it's 1, some of it's 3, some of it's 5, some of it's 7, 10, and it's really hard to keep track of. But that Form 1023, you have to keep permanently. And if you cannot present it to someone who requests it, it can be a $20 day fine up to $10,000. So if you don't have your Form 1023 available for public inspection, you need to contact the IRS. You do that through Form 4506A and request a copy of your Form 1023. And there's other things that you have to keep permanently. Then there's things that you have to keep 10 years and 5 years. So if I could go on a long time about that, it'd be easier for you to look at a document destruction policy. There's also the public support test. Now, the public support test says basically you have to receive at least a third of your funding from the public. This is to make sure that you don't have one donor basically use your 501c3 as a private foundation. So all the money that comes from the government through other 501c3s is 100% public support. So the money that you're getting from state CASA is 100% public support. But if you have a private donor come in that wants to give you $50,000, you may not meet the public support test that year if that is more than 66% of your total gross income, because a third of your money has to come from the public. So that is just something to be aware of. And that test is on Schedule A of Form 990. So you can go to Form 990, Schedule A, pull up the instructions for Schedule A, and it will tell you more about the public support test. Another great resource is written by, it's an article written by Laverne Woods. She's an attorney out of California. She wrote an article called The Public Support Test, What Every Grant Seeker Should Know. And you can Google that and find Laverne's document. And she even updated it recently to reflect the changes in the public support test. It's a great article to give you a lot more information on the public support test. And then, of course, interested persons, which we briefly talked about on that duty of loyalty. The definition of interested persons changed in 2009. And you can actually find that definition on the instructions of the 990 tax return. So everything I'm telling you, you can usually either find through the IRS website, or you can go to the instructions of the 990 tax return and check for information there and to verify all this, because you'll have some people on your board that won't want to do this. And so you may need backup to show them, and most everything you can find on the IRS website or again on the 990 instructions. So those are the federal considerations. We also have some state considerations and additional state requirements. One is a 512E tax return. That is a one-page reporting document to the state of Oklahoma. It's not a big form, but it needs to be filed annually with your 990 tax return. The other thing that gets our organizations in trouble is they think because they're tax exempt that they are exempt from all taxes, and that is incorrect. You are not exempt from paying sales tax unless you have filed a form with the Oklahoma Tax Commission and have received a sales tax exemption. Those are getting more and more difficult to receive, and I don't know that you would qualify for that any longer. You can go to the Oklahoma Tax Commission's website. You can pull up the sales tax exemption application, fill that out. You'll see that there are categories that are on there, and if you can't check one of those boxes, then you can't receive your sales tax exemption. Even if you receive a sales tax exemption, so when you go to Walmart, you don't have to pay sales tax on your purchases. This does not mean that if you're selling items that you do not have to collect sales tax. So make sure if you're selling items that you are also collecting sales tax. Sales tax is a transition, or is a anytime something transfers from one person to another and there's a sale, there needs to be a sales tax. That's how the state gets a significant portion of their money, and they are cracking down on sales tax, people who are not paying sales tax. So let's make sure we're looking, if we're selling items, that we're collecting it and that we're paying sales tax unless we have a sales tax exemption. You also need to report new hires to OESC. Now, if you have never, ever done this in the past, don't worry. Just go ahead and start now. The last time I actually called OESC to talk to them about this, they were very nice about it, and they just said, no, let's just go ahead and get started. And so I don't think you'll have any issues. I don't think that mentality has changed. So if you haven't done it, please start doing it now. You are also not exempt from paying workers' comp insurance. So let's make sure you're doing that. That can get us into all kinds of trouble if we're not paying for that. So just check in, just ask your staff if that's being done. The other thing you need to check on is unemployment insurance. If you have 4 or more employees, and some of you do not, but this includes part-time employees, you need to make sure you're paying your unemployment insurance. If you choose not to do so, or if you've just failed to pay your unemployment insurance and someone files unemployment and you're required to pay, then the organization is self-insured. That means that the organization is going to have to pay those unemployment claims. And if you have failed to ever look at this, you need to ask yourself the question on if that's a gross admission and if the board members could be held personally liable for not paying your unemployment insurance and therefore becoming self-employed. So please go back. It's very important to look at that. Many payroll companies do this for you, but make sure if you're using a payroll company, ask them if they're paying your unemployment. Sometimes they'll pay your workers' comp, but maybe not if you haven't asked them. So go back to your payroll company and make sure that this is taking place. While I'm talking about payroll, the one thing that we cannot get out of is paying payroll taxes. And board members can be held personally liable for not paying payroll taxes. And a while back, I had a treasurer call me who she did not know, she had not checked, but their organization had not been paying payroll taxes. The executive director had been handling payroll and they were running short, so she didn't pay the taxes. Then the executive director left and they did not know that they had been getting notices from the IRS that the payroll taxes had not been paid because the executive director was the only one that was opening the mail. The treasurer did not know until the IRS seized her personal accounts, personal banking accounts. And that's how she found out that the payroll taxes had not been paid. So the IRS can go after the board members' personal assets for failure to pay payroll taxes. So let's make sure we're doing that. So this unemployment insurance and the payroll taxes are both things that can lead back to personal liability on behalf of the board. Okay, one more little thing is that you have to file, and that is charitable contribution registration. If you are raising money in the state of Oklahoma, you have to file with the Secretary of State's office. So you're going to go to the Secretary of State's website and click on forms, and you'll have to scroll down a little bit and you'll find the charitable contribution registration. And I've got another slide on that here in just a second that will talk a little bit more about that, but it is an annual filing. So I've just kind of have it here in your laundry list to make sure that you're doing it. And of course, the Open Meeting Act. We've gone around this quite a bit with CASAs, and you are subject to the Open Meeting Act at this time. We do want to try to get that softened at some point through the Attorney General's office. That has not happened. So at this time, you're absolutely subject to the Open Meeting Act. And the Oklahoma CASA Association can talk to you more about the Open Meeting Act. You have to post your meetings. If you're getting state funding, you post your meetings at the Secretary of State's office. If you're getting additional county or city money, you may also have to post it there. And then that means you're going to post your meetings, and then you're going to have to open your meetings up to the public. One thing that we're supposed to be doing during that time is roll call voting. And the other thing that can hang us up is if our bylaws say quorum is a third, the Open Meeting Act says quorum must be a majority. You also cannot do proxy voting. So you need to look at your bylaws to make sure that your bylaws meet the requirements of the Open Meeting Act. There's notice requirements in the Open Meeting Act, and then there's an entire section on the executive session and what you can go into executive session for. You need to keep minutes during the executive session. And some attorneys will tell you that you don't necessarily need to do that. I'm going to tell you that you do need to do that. I believe that executive sessions, you have to keep minutes, and if you do not, that is a good way to be subpoenaed, because how are we going to know what actually occurred in the minutes without them getting you on a witness stand? So I think it's definitely in your best interest to keep minutes of executive sessions. And executive sessions are very limited. And that's why I've put on your list, your laundry list of state requirements, how to order the Open Meeting Act book, because we need to make sure that we are following the Open Meeting Act. Now, here's some information on that charitable registration. Just a little, you just file it with the Secretary of State. It's an annual filing. If you're under 10,000, it's only $15. Otherwise, it's $65. You renew it annually. You have to maintain it for 5 years. Technically, even though the form may say so, the Secretary of State's office is in the process of removing that you have to attach your 990 tax return. If you do attach your 990 tax return, please make sure you remove Schedule B. That's your list of donors. That is not public information. So make sure you're taking your Schedule B off. Technically, you no longer have to attach your 990 tax return. The form may still say so, but I'm hoping that that form will be changed any day now, that it says you do not have to attach it. Of course, there are a few exceptions: religious programs, educational institutions, fraternal organizations, and then dollars raised for a named individual are not tax exempt. So if you put out there that we're going, Susie needs a kidney transplant, she's one of our CASA kids, and if you want to give money to help Susie, write your check to wherever, those are not tax deductible donations. I need to be very clear about that. There are not tax deductible donations, no matter how needy the child or individual is. So if you're going to do that, you need to be very clear to the donors, or it's a gift. At that point, it's not a donation, it's a gift. You need to be clear to them that there will be no tax exempt letter coming for a charitable donation, because it is not a charitable donation. All right, here are those annual filings. We talked about that 990 tax return. Now, when I keep talking about all these questions on the 990 tax return, on that duty of loyalty, I'm actually talking about that big tax return that's equal to or greater than $200,000. So if you're filling out that tax return, that's where you will see all these questions on that duty of loyalty, and all these questions on page 6 about, do you have a conflict of interest policy? Do you have a whistleblower policy? Do you have a document destruction, document retention policy? That is also going to ask you on page 6 of that big 990 tax return. Have you given any committee the authority to act on behalf of the board, and are they keeping minutes? So those are all things that are showing up on that big 990 tax return. Some of you, if you have receipts less than 50,000, that you're only going to file a 990E postcard. And then if you're up to 200,000, you are going to fill out the 990EZ. Some organizations will even if they're under 200,000, will still fill out that big 990 tax return that has all those questions on it, just so they can show donors. They use it as a marketing tool, so they can show donors that, yes, we follow all these rules. We have all these policies. We do know what we're doing. And so it doesn't mean that you can't fill out the big 990 if you're less than 200,000. It just means you don't have to. And that's a discussion you'll have with your CPA. If you are selling items, not only probably do you need to have the sales tax discussion with your CPA, you also need to have the 990T discussion with your CPA. That means you could have unrelated business income. Now, items that are sold by volunteers are the exception to the rule. That's the biggest exception to the rule. But this is so detailed, so specific to a fact pattern that it's hard for me to talk about unrelated business income on a broad scale. But you have to know that if you're competing with for-profit entities that you may have unrelated business income. Sometimes rental revenue may count as unrelated business income. So make sure that these are the discussions that you're going to have with your CPA based on an individual basis on sales tax and unrelated business income, and whether you also need to complete those sales tax forms with the state and the 990T with the IRS. All right, here are our levels of responsibilities. And this is a huge area for all organizations of any size. And the best thing that we can do, I've literally put lines. That means I want you to stay in your power alley. I don't want you crossing the lines because that's where we have a tendency to get in trouble. So when I go into organizations, and sometimes I ask to be an interim executive director until we can get things lined out to bring in a new executive director. It's a very short-term job that I do, but sometimes it needs to happen, especially when I get the call that says we've had 5 executive directors in the last 15 years or the last 10 years. I know that we really don't have an executive director problem. We have a board problem, and a lot of board members don't like to hear that. But technically that tells me, I'm stereotyping, but when I hear that, I know I have a board that is micromanaging the executive director and the staff. And that is not your responsibility. And I'll get into another slide that's going to talk just about your responsibilities. But you're supposed to stay at that oversight. You oversee the executive director. If you start talking to the staff and you start trying to manage the staff, you damage that executive director's credibility and that individual's ability to manage staff. I actually had a federal agency call me and pay me all money to go out to California to talk about this very issue, because I had a board that had an executive director and they decided that they wanted the CFO, they had a CEO and a CFO, but they wanted the CFO to also directly report to the board. So instead of having our executive director and the staff, we had the executive director and the CFO that both reported to the board. They were on equal footing. The executive director, or the CEO, and the CFO got sideways with each other. The CFO is going to this portion of the board, and the CEO is going to this portion of the board. It caused the split in the board. The federal agency said, you fix this or you're losing your $8 million federal grant. And that's when I got the call. And we had to talk about this chain of command and why it is so very, very important. And if you've been in the military, think what it would be like to be on the battlefield, which I cannot imagine. But if you were on the battlefield and you had 2 different individuals who were your commanders telling you to do opposite things, that is a recipe for disaster. And that's why we have to make sure we keep this chain of command intact. So I'll get into your duties in just a second. Then we have that executive director role. Their job is to run the business. Now, if you don't like the way they're running the business, you don't step in and micromanage them. That's when we do performance evaluations. We give them better guidance. We may even look at some executive director coaching, but you do not step in to do their job. It's not your job to tell them how to dress. It's not your job to tell them what their office should be painted, color their office should be painted. I mean, these are actual examples that I've run up against. So if you don't like the executive director, if the executive director isn't doing their job, you provide them support, you get behind them, you prop them up, you help them. If they can't do the job, you fire them. But you don't micromanage them. Then it's their job to take care of the staff. Now, even with staff, if we have staff trying to cross those lines, we have staff trying to go to the board, if it's a whistleblower action, absolutely. If it's not, you're undermining the executive director. So let's be cautious with that. Now, I like to see staff in board meetings. I like to see them reporting to the board. We shouldn't, if we have an executive director that won't even let you get close to the staff, we may have another issue. But don't step in and direct the staff. That's the executive director's job. And then for staff, even if they try to change lines and go to a volunteer level, we can't allow that. They cannot volunteer in the same position in which they get paid. If they do that, that violates FLSA laws. We have to pay them for that work. So that becomes a huge issue. So it is very important that we stay in our power alleys. I love it when board members say we don't have to go through the CASA trainings because we're on the board. So we're going to volunteer, but we don't have to do the training. No, that's incorrect. If you're going to become a volunteer and you're going to become a CASA worker, you have to go through the volunteer program just like every volunteer. Every other volunteer, we have to stay in our power alleys or we have to do the training. And we shouldn't have our paid staff be on the board. If we do, they're interested persons. We're doing business with our board members. Now we have to report that on the 990 tax return, and it looks bad to donors. So I want you to think about your levels of responsibility, and I want you to stay there. And by the way, we've got some changes coming out to exempt versus non-exempt employees and their level of pay. It was the Department of Labor was talking about you had to be paid $50,000 to become exempt. They backed off to that to $47,000. Currently, it's at like $23,000 something, $455 a week. And so we're going to see some big changes in that area. We try to push information down to you as we receive it, but right now we don't know what that's going to look like. So please stay in contact with the State CASA Association, and we'll be monitoring that closely. But let's make sure we stay in our power alleys. So what are your responsibilities? And I have a list here. You are going to manage the short-term and long-term planning of the organization. Now, strategic planning is very difficult for tax-exempt organizations because it's all based on grants. We could do a long-term plan being over the next 5 years and 6 months later lose a grant or gain a grant, and it's going to change our planning. But you do need to at least think about where you want to be in the next few years. That is your guidelines for your executive director. Also, you hire and fire the executive director. You set their salary, you do annual reviews, and you do succession planning. What happens if your executive director wins the lottery? I got in trouble for saying got hit by a bus by some of my executive directors. So we'll say your executive director wins the lottery. So she is gone. What happens? She doesn't show up for work tomorrow. Do you have a succession plan? Putting a board member in that role of executive director is usually not the best option. And about once or twice a year, I have a board that has been convinced by one of their board members that that board member should be the new executive director. And that is a bad plan. So, because then they start sabotaging the executive director, and this literally happens about once a year. So I want you to have a succession plan. If your executive director doesn't show up tomorrow, what happens? And then make sure that you are cross-training on everyone, that the staff is being cross-trained. So if our executive director gets sick or needs to take an extended leave, that we have people who can step into that role, so we don't have to let that person go, that we can just make sure that we cover for them. It is also your job to set policies. Financial policies, personnel policies, fundraising policies, you need gift agreements. What happens if somebody gives you a big gift? So let's make sure we're looking at all those policies. Now, in your bylaws, in 2009, another change the IRS made was if you change your bylaws and it's substantial in nature, which could be that we've gone from 7 board members to 9 board members, could be considered substantial because it affects voting rights, that we have to report that on the 990 tax return. So let's make sure that we pull our policies out of our bylaws. So our bylaws should deal with governance. We're going to talk about that in another section. And then we should have policies. That is even another section. But I don't want your policies in your bylaws. So, but you need to be setting policies at the board level. Also, financial oversight. It's a very important job. Making sure that you understand where the money comes from and where the money's going. Most of the people that sit on boards are not CPAs. So let's make sure that, I tease about the financials being in English, but that's so us non-CPA types can understand what's coming in and what's going out. Then your final job as a board is to do self-evaluations and monitoring. As a job, how are you doing? I mean, you need to evaluate yourself just as you're evaluating your executive director. Are you showing up at meetings? Are people participating? Are you fundraising? Are you helping your executive director? How are you doing as a whole as a board? And you should probably have a governance committee that looks at your board and analyzes your board's strengths and weaknesses and then recruits to find people to fill in those weaknesses on your board. And I'm hoping that you have enjoyed this. Please be aware that you can always go to www.irs.gov. They actually have a fairly extensive website and find information there. When you go up to the top right-hand corner, you'll see topics. You'll want to click on charities, and it will get you to another page where then you can do additional searches on public charities. Thank you for joining us.